Chairman, Madam Attorney General, the central issue to me is this perception, frankly rooted in some realities of a dual-track or two-tiered justice system. And I know that you have dedicated your career to the pursuit of justice. I know you work for a blindfolded woman who's holding nothing but a set of scales. And I think it's important that she's blindfolded because she shouldn't see the race, the gender, the socioeconomic status, the fame or lack of fame of the person in front of her. And I'm sure you've experienced it like some of the rest of us. It's not just the suspect or the target or the defendant. The witnesses have to have confidence in the justice system. The jurors have to have confidence in the justice system. The public has to have confidence in the justice system. So this dual track, different set of rules for certain people than for others. It frankly should not matter whether you are running for president or running late to a kid's ball game. The same rules ought to apply to everyone. So let me ask you this. Why do you think it's important to use official email to conduct official business?
I believe it's important to do that. I think that certainly every department has chosen to craft the way in which they carry out their business, and it provides for a way of doing business in a secure system.
So you use official email to conduct official business?
Yes, sir, I do.
Okay. And do you ever email, send or receive classified information on personal email?
I do not.
I doubt you even use your USDOJ.gov account to send classified information, do you?
We have separate systems.
Right.
So there would be a separate
classified system
for that.
Right. So not only do you not use personal email to do it, you don't even use your USDOJ.gov. You have a separate, dedicated system to handle classified information. Why?
We have a separate system to handle the security needs.
But my question is why? Why is it important enough to you to not use personal email to conduct public business and to use a separate, more safely guarded system when you do handle classified information?
That is the practice that I've certainly always followed. It
But
allows
it's not
for the
just
protection.
it's not just a personal preference, is it?
No, it allows for the protection of the information, both on a regular system, because again, that's still sensitive, law enforcement types of matters, and then a classified system for separately classified information.
What element do you think was lacking in the statutes that you evaluated as it relates to Secretary Clinton?
So let me, again, as I've indicated before, and I want to make it clear that, as I indicated before, while the reason why I will not be going into the analysis that was provided and the discussion that we had between myself and the team is because we protect our teams and that they have to be free to provide information and analysis in a confidential way without the fear or impact of there being a political influence on that.
I understand
and that is why I have not gone into that type of discussion. What I can tell you is that the team did evaluate the relevant statutes that were considered in this investigation. They looked at all of the facts and evidence, and as in every case, they applied them to that statute to determine whether the elements had been met. But my specific question
to you, Madam Attorney General, is what element of which offense did you find lacking from an evidentiary standpoint?
Well, I would say that in order to answer that, I would have to go into the entire level of analysis.
Don't you think
Yes.
public perception in a single track justice system is important enough that you could at least touch on what you thought was lacking?
Congressman, in this case, we have taken the unusual step of discussing it in ways that the department typically does not, in order to provide more clarity into this situation. And while I understand that it is frustrating to a number of people, civilians as well as members of this body alike, we have taken extraordinary steps to discuss this matter in ways that typically we do not,
well, let me ask you this.
When charges are not brought. And as I indicated before, just so it's clear, my reasons for not going into the substance of the information that I receive and review before I made my decision to accept the recommendation are that the teams that I work with, whether it's this case or any other, be free to provide confidential analysis, discussion, without the input of any
With all due
kind of
respect, Madam
political
Attorney General,
influence.
you can do all of what you just described and still tell the people what element. I mean, the elements of a criminal offense are public, so there's no secret there. And for you to go through the elements and say, as Director Comey did, he said there was no specific intent. I'm out of time, but I suspect you have prosecuted reckless homicide cases, haven't you?
In the context of violent crime.
How about involuntary manslaughter?
For the department or personally?
No, just as a prosecutor. There's involuntary manslaughter, there's reckless homicide, there's felony DUI where you really didn't mean to hurt anybody. You really didn't, but you did. And this lack of specific intent is not a defense in any of those cases. So I think the public would like to know how you determined she did not have the intent to break the law and why you are applying a specific intent requirement here when you don't even do it in certain homicide cases.
Well, Congressman, as I've said, I think you've mentioned a number of state cases there. But as I've said, the reason why I am not going into the discussion I had and providing that particular level of information, although the FBI director did choose to do so, is that the information the team provides to me on this or any other case has to be given in a zone of confidentiality so that they can be clear and sure that there's never a political overtone to their decisions, nor will I apply one in accepting their decisions. That's why we have taken the unusual steps of providing greater information, as frustrating as that has been for a number of people to have additional information. That's why I took the unusual step of clarifying my role in this investigation.
Well, I'm out of time. The only thing I find frustrating is that even after this and Director Comey, people still believe that if you are famous, there's a different set of rules than if people don't know your name. And I think you're missing a wonderful opportunity to say with specificity which evidentiary element you found lacking. So Congress can go fix the statute if you think we need to, but right now, we have no idea whether or not a President Lynch could do exactly what Secretary Clinton did, or whether President Clinton could do exactly what Secretary Clinton did. And I think that lack of clarity is bad for the Republic, quite frankly. I would yield back.